receipts, screenshots, and shade. That's just some of what's going on in the plaintiff's opposition to the defendant's motion to dismiss in the Tati Westbrook defamation suit that we're going to get into. Holy shit, you guys, it's 125 pages of 2 motions, a bunch of declarations, and a whole lot of information. This is a first look. I know we're going to talk about this more, but for right now, I've got my facts not fuckery gavel. We're going to call this meeting of the law nerds to order. Wherefore comes the case of Tati Westbrook versus KJ and Without a Crystal Ball. Now is the time to talk about Tati's side of that motion to dismiss. Let's just get into it. I'm Emily D. Baker, the badass lawyer, host of the Get Legit Law and Shit podcast and legal commentator. I've been a licensed attorney for over 15 years, but I'm not your attorney, not legal advice. I am a big fan of the cursey words, so headphones are recommended. This is where the law nerds unite to break down the news stories that you want to hear about with facts, not fuckery. For those of you that don't know me, cursey words, I mentioned it in the intro, we're going to do the things. Today I've got my facts, not fuckery shirt on because we are going to talk about all the facts in this motion. Let's give a brief breakdown of where we're at. Tati Westbrook has 2 active lawsuits going on right now. In one of them that we hear on the Law Nerds, Emily D. Baker YouTube. Is it LawTube? I mean, I know there's BookTube and BeautyTube. Are we LawTube now? Can that be a thing? We're LawTube now. I'm just going to go with it. Totally a thing. Tati has 2 suits. One we call the partner suit. That is where Clark Swanson sued Tati Westbrook. This is a lawsuit caused by the defendant's greed. It's that one. That's separate from this one. This is the Tati Westbrook suing another YouTube channel, KJ Without a Crystal Ball, for defamation in the state of Washington. That's the case we're talking about today. What has happened in that case so far? Tati sued, complaint was filed. Then very shortly thereafter, there was a motion to preserve evidence that alleged shit got deleted. Then we were waiting on a response to the motion to not delete your shit. There were videos made by KJ. There were statements on Twitter. There were things that happened. And then instead of getting a response to that, we got the defendant's motion to dismiss. We've talked about it on this channel. I'll link all the things, but it was kind of a fruit salad of all the things. I'll pull it up real quick before we get into this motion. Then we got a stipulation with regard to the motion to preserve evidence, the motion to not delete your shit, saying, we agree, shit will not be deleted. We don't agree about all the other stuff, but we agree that there's an obligation in litigation, which, basic, because there is. So let's pull up that defense motion first, and then we will get into plaintiff's opposition. Because I have other content on it, I'm not going to go all through it. We're just going to go over real quick the things that are going to become relevant and applicable. Relevant stuff's important. We like shit that's relevant. So we're going to scoot me over to the side here. I'm going to leave a banner up in case you guys want to follow me on the socials so you know where I am. And we're just going to jump into it. Today, I should mention, we're not going to edit. This is a first look lawyer reacts coming to you, and I will do other content on this, breaking down the law. Today, we are not doing a deep dive into the law that's being argued. We are doing an overview of everything that's in here because these declarations are fire. And I want to talk about the stuff in the declarations and all the little lawyer shade and the sassy footnotes and some of the great little lines from this. We will get into the law breakdown, a full breakdown of the law another time, and with some other lawyers because it'll be really fun because there is a lot of law to be argued here. Today is an overview. This is the defense motion. Again, KJ and Without a Crystal Ball is the defense because they are the ones being sued. So they're the ones playing defense. Plaintiff being Tati Westbrook, James Westbrook, and Halo. They're the ones who are suing over the defamation claims. Now, everything in these, though we want to see facts in lawsuits, especially in declarations, these are all allegations. This is tremendously stressful for the parties involved. We're just breaking down lawsuits here, folks. This is the defendant's motion to dismiss. I didn't like this motion. It is a word fruit salad The law is buried. Some of the law is California law. And this whole thing, this introduction spends so much of it going through Jeffree Star, 2Rs, and Shane Dawson. It goes into Carmageddon and Dramageddon and PewDiePie and Trisha Paytas and all this shit that I don't think's relevant at all. It talks about the fact that KJ was the first to report the business partner suit. It talks about it like 6 times in here. Hyperbole, I think it's only like 4. But anyway, it's in here multiple times. And then it goes into some of the law, but it doesn't really state the law through here. It talks about the business partner lawsuit, which really isn't relevant, and then relies on the business partner lawsuit, in my opinion, to say that, look, Tati lives in California. Most of the basis of this that I can gather is that there's no jurisdiction in Washington, so the defense is trying to get the case moved to be filed. I think Tati's side would choose Minnesota because they get to pick where to file the case, but I don't think this motion is going to succeed, and we will get into that. But they don't talk about any of the law that they are moving under. They don't talk about the rules of federal procedure. They don't talk about if this is a 12b6 motion or 12b1 or 12b2. They're not even stylistic option differences. They are basic legal writing issues that made this motion tremendously frustrating to read, which made the plaintiff's motion a breath of fresh air. And you can all compare and contrast the videos of me covering this and the video I'm doing right now covering that. But I wanted to get to the declarations because the declarations are going to come up. This is the request for judicial notice. This will come up because it is a separate motion. There is a separate response to it from Tati's attorney, who the law nerds have fondly nicknamed Saltsy. The lights are actually green today. Saltsy has posted on Instagram in a Slytherin costume. So we figured this motion's a little Slytherin-esque. It's a little Honey Badger-ish. So we're going with the green lights to rep Slytherin, and maybe a little bit of jealousy. There might be some jealousy after this motion because Without a Crystal Ball's motion does not have sassy footnotes. And we love a sassy footnote. And Saltsy, brings us the sassy footnotes, and we appreciate it. This is a request to take notice of the contents and the fact that there's the business partner lawsuit with Swanson and a whole list. Here's the business lawsuit. A whole list of YouTube videos, y'all. And we went through them in a live video and clicked on all the videos, and it's like Shane Dawson reacting to Breaking My Silence, and it's Trisha Paytas saying that she thinks that Tati is dumb as hell. Like, that's literally the name. So it's this whole salad of shit that isn't labeled, isn't defined. It's just this appendix of stuff with videos and then news articles. The declaration of Michael P. Brown, the attorney for KJ, is referenced mostly because he cites to Zillow as authority. Okay. Pulls up stuff from Tati's Twitter. We'll get into it. And then there is a declaration from KJ herself, or in this, it is Catherine Paulson, that she was the first person to report on Clark Swanson's lawsuit, that she is the sole owner and sole employee of Without a Crystal Ball, which comes up, that she's a resident in Minnesota, and that she has never set foot in Washington. To my knowledge, neither I nor Without a Crystal Ball has any sponsors or subscribers in Washington. To my knowledge, neither I nor Without a Crystal Ball derives any income from the state of Washington. I did not conduct research in Washington state or rely on any Washington residents as sources. These statements come up. The plaintiff's response heavily leans into the fact that they believe a lot of these statements are false. We have talked about it on this channel, my concerns that there are statements in this sworn affidavit before the court that are false, and that will be very, very problematic. My understanding was that Tati and James resided in Los Angeles until Ms. Westbrook stated personally. There are some things to contradict this. So, and the things, when I say things to contradict it, it's links to videos of KJ contradicting what she put in this declaration, which is not going to play well in front of a court. The plaintiff's opposition. This is their response. The defense will have the opportunity to respond to this before it's heard in court. Let's get into it. Introduction and relief requested. This talks about over the past 19 months, KJ and Without a Crystal Ball have engaged in a course of conduct specifically aimed at harassing Tati, James, and Halo. They have said in at least 80 YouTube videos and Instagram videos and in more than 100 postings on Twitter. So this is more than is alleged in the complaint, but this is going to that pattern of harassment that they're really alleging in certain claims in the complaint. Defendants filed a motion to dismiss the complaint, asserting jurisdictional failure to join a necessary party and failure to state a claim arguments. First footnote at the gate. As defendants failed to cite 12B, the federal rule, at any point in their motion, truth, plaintiffs assume that the procedural basis for defendants' objections to the complaint are made pursuant to 12B1, 12B2, 12B6, and 12B7, because the defendants never, in their motion, ever once state the section that they are relying on and bringing the motion under, and it is infuriating, and it infuriated me, and it was annoying to read, and somewhere there is a law clerk that is sitting there going, the judicial law clerk or research attorney going, what in the ever-loving fuck is happening with it? Is this under 12B2? Is this under 12B6? And I got annoyed. Someone got paid through Salty's firm or the Washington firm to sit and parse what these arguments were and try to guess and attach them to the law, which a judge isn't going to do. It's like that scene in Clueless where Cher's doing the debate with the redheaded chick and she's like, Mr. Geist, if she doesn't do her assignment, I can't do mine. Like, that's how I felt about the entire motion for the defense. Like, if you don't cite the law, what would you like me to do? However, they definitely pointed it out and made everyone aware right quick that the law was never stated, because it becomes very obvious in that motion that the law is never stated once. In addition to defendants relying on the misleading declarations of Paulson, there we go, right out of the gate. Another footnote, also referred to as Catherine Paulson and Catherine, spelled differently. Let's just talk about the fact that it's spelled differently. Catherine Paulson and Catherine Mansk Paulson in the motion to dismiss and supporting declaration. So again, a little bit of shade, but also a little bit of clarification with the fact that they refer to her in her own motion by 3 different names. Katie, Catherine with the Y. We're on page 1 of 125, y'all. Out the gate. We're coming in hot. On this. Don't rile the lawyers is the rule, because then the lawyers will bring the heat. In addition to defendants relying on the misleading declarations of Paulson and her attorney Michael P. Brown to support defendants' jurisdictional arguments, they're now calling both declarations misleading. Misleading the court as an individual is one thing. Misleading the court as an officer of the court, as a lawyer, whole other ball of worms. Ball of worms? That doesn't even make sense. Ball of wax? Bag of worms? I don't know what analogy we're going for. It's a whole other shit show. As well as obsolete, inapplicable federal case law and California state law. The lawyer shade, because this is a Washington case. And when I saw they quoted California state law, I was like, why though? Because not relevant or applicable, but they did it. Page one, we've got all of the shade. Like, just nope. We're noping our way down the defense motion. Defendants failed to acknowledge that their deletion of evidence. This is like the fourth thing that we want to talk about. Particularly YouTube videos destroyed evidence relevant to their jurisdictional objections. Footnote 3, please see motion to preserve. It's all in there. In the first paragraph here, really, you get all of it summarized. All the things. We don't need 7 pages talking about Shane Dawson, Jeffree Star, and Trisha Paytas. This one paragraph basically sets the stage for where we're at. The plaintiffs are saying that the 2 declarations are misleading, that evidence was deleted, that there was no law stated, and that the law relied on is obsolete and inapplicable, and from the wrong state. That's what we're in for 125 pages. Get a snack. Now's the time. And then, we love clear writing. The court to deny the motion to dismiss because defendants have sufficient minimal contacts with the form through their research, published of defamatory statements in the form. I would imagine that's published defamatory statements in the form, and targeted known residents of the state of Washington. 2, the court has subject matter jurisdiction over all plaintiffs' claims through diversity jurisdiction, which is not destroyed by the inclusion of the Doe defendants, which is an argument in the motion. 3, there's no required joinder of parties. This is basically the argument that you can't sue me for defamation because Jeffree Star and Shane Dawson said mean shit too. So you can't just sue me, sue them. That's how I read. When I read that part of the motion, the whole thing just read to me, again, like that scene from Clueless of like, but they did it too. Irrelevant. What Tati said in Bye Sister is irrelevant to whether she was defamed by KJ. That's relevant for her and James to sort out. Anyway, there's no joinder of parties under Rule 19. For plaintiff's complaint satisfies the requirements of Rule 8AB and states claims for which relief that are plausible on the face of the complaint. I read that wrong. And states claims for relief that are plausible on the face of the complaint, which is the heart of the 12b6 motion, though it was never stated as such. You have to state a claim for which relief can be granted, meaning you have to come to court saying, this is what happened, and this is how we fix it. You can't just come to court asking for something where relief cannot be granted. We've talked about this in connection to other lawsuits. I thought the headline was shady and I fucking loved it. I'm just going to be honest. Statement of relevant facts. Because when we're in defense motion, the introduction is all facts and it's a page, 2 pages, 2.5 pages, and then the statement of facts, most of which are not relevant. I mean, all of which are not relevant. Go watch my video on that. But now we've got a half a page, 2, 3, like 5 pages really of facts that don't get into anything. Like, why do we care if Shane Dawson is accusing Miss Westbrook of fake crying? It's not relevant to this. So the statement of relevant facts to me just reads like a dig. It's just like defendant KJ Paulson and Without a Crystal Ball's content about plaintiffs demonstrate form contacts. This is getting into the argument about the fact that there is jurisdiction. Washington can hear the case, and it goes through KJ's own statements about what she's done in the state of Washington, which directly contradicts her own sworn affidavit. This gets into a video that I'm sure if you follow this case, you've seen it. KJ talks about her plan to dig into Tati's background and expose her. This is the May 31st, 2019 video. It goes to footnote 4. These are all listed in a declaration, but we've got Tati Westbrook declarations and James Westbrook declarations and links to all of these videos. And I'm going to link those down below. They're all Dropboxed because some of them aren't available anymore, but they're linked for the court, but I feel like they're also linked for us. So I'm going to drop them below if you want to go and play Super Sleuth and see these yourself. Most of the declarations have timestamps in them, so you can enjoy that. Mary. Defendants state they were digging into Tati's background and looked all over the place, everywhere. Defendants also reference civil judgments and tax liens that they found from the state of Washington. I've seen that video. Defendants then go on to indicate that they conducted more in-depth searches than a simple background check. Defendants also state that people can actually go state to state and try to pull stuff up, and that people can go to the different databases within each state to find information, which defendants admit is what they did to get personal information regarding Tati and her family. Defendants also assert that Tati's address is online too, but defendants were not going to provide that. Defendants further state they continued digging through more and more information, going through marriage records and birth certificates, specifically asserting it was weird they could not find Tati's birth certificate. Tati was born in Washington. Defendants then go on to discuss extensive public records and social media pages they searched regarding Tati's parents, who are Washington residents, her 2 sisters, one is a Washington resident, and lamenting how they could not find information regarding Tati's father, which led defendant to theorize, we've seen the clip, that Tati's father is either dead or in the mafia. There will be a link to that video in this motion and in the declarations below. Subsequently, a video entitled "The Past James and Tati Don't Want You to Know" uploaded to YouTube on or about June 2nd, 2019. Defendants continue their campaign of harassment and plan to expose Tati and her family. Defendants discuss the research they've done on Tati's family in Washington. This all goes to show that research was done in the state of Washington virtually by accessing records from the state of Washington, which goes, they're saying, to prove that I think the dual purpose of showing that KJ's declaration is not true and showing that there are sufficient contacts between the research she did to create the defamatory statements and Washington and this case and all the things. This comes up a lot, that KJ talks about court records they found in Washington state that they found through 3 weeks of nonstop researching to find all this information. And it goes in and talks about the statements KJ made in those videos. Those declarations have all of the links to these things. And so we'll go over it more in depth when we get to the declarations. More recently, in a video uploaded on YouTube on or about September 22nd, 2020, defendants admit that Tati and James moved back to Seattle, quote, actually a while ago. So before the declaration was signed, KJ is on video, according to this, saying that she knew that Tati and James had moved back to Washington a while ago from September 2020. It goes on to assert that Tati and James have not lived in Los Angeles or even spent a single night in the Los Angeles house since they purchased it. So it talks about it in James's declaration, and we'll address it then. Since 2019, defendants have published approximately 80 videos, as well as over 100 internet postings on Twitter and other social media maligning Tati, James, and Halo. Defendants' Washington viewership and plaintiffs' harm in the forum. This talks about the fact that there are viewers of the YouTube channel in Washington, and there are screenshots in James's declaration about that. But this also, again, dual purpose of showing that the declaration saying, I have no idea if I have any viewers in Washington, is, as they're saying, untrue. And let's go to that declaration again real quick and go to the language of it. So back into the declaration stating that, to my knowledge, neither I nor Without a Crystal Ball has any sponsors or subscribers in Washington. To my knowledge, neither I nor Without a Crystal Ball derives any income from the state of Washington. That goes against jurisdiction. Like, oh, I have no contacts. So they're very keen in plaintiff's motion to point out, no, you know that there are people that watch you from Washington. And this, again, all of this is based on declarations. So as we get into the declarations, we will get into it deeper. But they point out people in live streams that say, hey, from Washington, hey, from Seattle. They talk about the defendant specifically interrupted a live stream to acknowledge and say hello to Patricia from the state of Washington, and all the research that was done. In this footnote from the James Westbrook Declaration and the Walker Declaration, it states, testifying that she is a Washington resident and viewed defendant's social media content about Tati, James, and Halo, including YouTube and Twitter, beginning in May 2019. There's other declarations showing defendant's proclaimed follower/fan, Lori Ann Barnhart, the Twitter user at BloodTall, whose online information indicates she's a Washington resident, and one of their, being KJ's, fiercest and loyalist fans. Twitter showing a screenshot of defendant's computer screen containing defendant's Twitter direct messaging list, which appears to include Lorianne's direct messaging. So showing all of these contacts between Washington residents and KJ. And then in James's declaration, it goes on to say that you can find that information on your YouTube analytics really easily. And I'll pull that up and show you mine too. Tati and James, Washington residents, this goes into when they moved, how they moved, that their corporations are mostly in Washington, why they moved, that they paid taxes in Washington, getting into who Tati is, that she has over 9 million subs on YouTube, 2.5 million on Instagram, 1.3 on Twitter, that because of that, she is a recognizable figure, highly recognizable figure. We're not arguing that she's not a public figure. They're not arguing that anywhere. But because she's a recognizable figure, her posts are sometimes created by others, including her social media assistant. And for personal safety, she will post at random times when she is not in the reference location, so the public does not know exactly where she is at a particular time. A lot of people do that. I will often do that and post things after I have left or the next day. A lot of people do that when they want to share things, but don't want to necessarily share it where somebody could be looking on Instagram going, oh my God, you're at the farmer's market right now too. No way, me too. She goes into that because of the Michael P. Brown declaration in the motion to dismiss saying, look, she's saying she's here. She's saying she's there. That means this. This is going, no, it doesn't mean this because you have failed to take into consideration the fact that not all of these posts are made by Tati herself, that she has help with this, and that she will reference things when she is not there as a part of maintaining her social media. Evidence relied upon. These are the declarations of James Westbrook, Tatiana Westbrook, Kim Fulmer, Hope Walker, and Mary Strome. And they're all attached. That's why this is so long. Well, part of why it's so long. It's also so long because Saltzy et al. Got a extension of page length because KJ's attorney blew past the page limits. And so in the minute orders from the judge said, look, I'm just granting an extension in length to the other side because you took an extension of length, but here's my standing order. Don't do it again. Essentially is what that said to me. The court should deny defendant's motion to dismiss claims under 12b1 because this court has subject matter jurisdiction, meaning the court can hear it here, and then they go into why. The court has original subject matter jurisdiction over this entire civil action, which is, again, a note going back to the fact that the defense argues that one of the claims is a criminal claim and not a civil claim. So it's again saying, no, these are all civil claims. Defendants further erroneously assert that this court lacks subject matter jurisdiction over the action due to the inclusion of DOE defendants. And then the DOE defendants are the defendants that are unnamed yet. In the complaint, they're alleged to be people who helped or communicated or shared information with KJ. That's what's alleged with the unknown defendants. Before making any ruling on the case, every court, even the Supreme Court, must determine independently that it has subject matter jurisdiction over an action, even when no party has challenged the matter. Defendants' arguments ignore the fact that both the Western District of Washington and the Ninth Circuit, which is the federal circuit that Washington's in, have determined that federal courts have subject matter jurisdiction over a civil harassment claim brought under RCW 1014 by ruling on and affirming such a claim. So the defense is saying, oh, the court doesn't have jurisdiction on this. The plaintiffs are saying, no, it's been discussed in multiple cases that we do, in fact, have this jurisdiction as a matter of law. And it then, in the footnotes, cites that law. In fact, it goes on, the Western District of Washington expressly rejected the argument that subject matter jurisdiction did not exist in such an action, which is essentially the argument that is made in the motion to dismiss. I'm just going to note that I love the use of the word inapposite. It's like all of the legal words in here. It's so fun. Going to the allegation by the defense that this is a criminal charge in the civil harassment, what the plaintiffs are pointing out is that Washington expressly distinguishes between civil harassment claims under RCW 1014 and criminal claims under RCW 9A.46, meaning the way they're saying this is like, come on, this is basic. Like, we shouldn't be fighting over this being a criminal claim because it misstates it. That's what the plaintiffs are saying to the court in that. The court should deny defendants' 12b1 motion because the inclusion of DOE defendants does not automatically destroy diversity. They state the law that defendant relies on, which is this Garter Bar case, and that the reliance they say is misplaced. More recent, which courts, when they have case law, just quickly, the case law builds. So there are older cases, and then the court will decide a newer case, and then the newer cases are generally the governing precedent because they give context to the other rulings. And then the context builds. And so you have to look at the trail of the cases to see which ones apply and to make sure that the newest one is good law. And then you go back from there versus going to the bottom and working your way up, like oldest to newest. When I do legal research, it's newest, and then you dig underneath it versus the other way around. And that's what they're arguing here, is that newer cases have called into question the rule in that older case. The court should deny defendant's motion to dismiss under 12b2 because it has specific personal jurisdiction over defendants for all of plaintiff's claims. And then it states the standard of saying, hey, court, this is what you use to decide it. And it is here The motion to dismiss is based on written materials rather than an evidentiary hearing. The plaintiff need only make a prima facie showing of jurisdictional facts to withstand the motion to dismiss. That's like a baseline. We just need to show enough. To satisfy this prima facie standard, the plaintiff have only to demonstrate facts that, if true, the court has to assume that what the plaintiff says is true for the purpose of jurisdiction only. To demonstrate facts that, if true, would support jurisdiction over the defendant. Uncontroverted allegations in the complaint must be taken as true, and factual disputes raised by affidavits must be resolved in the plaintiff's favor. And then it breaks down the minimum contacts test. Because we talked about minimum contacts in so much of the other videos, and we're going to talk about it in the declarations of like what research was done in Washington, our subscribers in Washington, we're going to go through this law pretty quickly. So this goes into really the law under it and this 3-part test, IRAC format, showing the test and then showing what the defendants did. They're saying to have sufficient contacts. Defendants searched through and relied on Washington sources for the harassing and defamatory stories about plaintiffs. In those stories, defendants discussed plaintiffs' significant Washington connections. Defendants knew or should have known that such stories had a viewership in Washington, and defendants published the defamatory statements in Washington, because YouTube, deriving income from such publications, because monetized, which they knew would cause injury to plaintiffs in Washington because they live there. The court should deny the 12b2 motion because defendants' contacts with the former are sufficient to satisfy the minimum contacts test, and then says, defendants' arguments against this court's exercise of jurisdiction fail for several reasons, not the least of which is because they rely on Paulson's misleading declaration as well as evidence submitted by defendant's attorney about which he lacks personal knowledge. This is a lawyer dig. The amount of different ways they say that Paulson's declaration is false, they say it in a number of different ways. There is stuff in here that directly conflicts with other things we've seen on the internet before this even came out. This gets into the test again, or continues on. I shouldn't say again, it continues on with it. This gets into all of the legal analysis of the different cases relied on, distinguishing the cases, stating the law, and then stating that similar to the actions of the writer and the editor in the Calder case that's talked about above, defendant's conduct meets the express aiming requirement for the effects test. These are the standards the court's going to apply in determining this motion because they searched through and relied upon Washington sources as part of their research for their purported expose on plaintiffs. And then goes on, defendants first announced their intent to expose Tati and harm her reputation and Halo's business interest, on and on and on about the same facts. And it talks about the fact that Tati and her immediate family are from Washington, that they are in Washington, including James. They talked about Tati's birth certificates, the looking everywhere, the financial records, business records. And then, in fact, in this same May 2019 video referenced above, defendants flippantly questioned whether Tati's father was in the mafia because they could not find any employment records for him anywhere, despite searching every Washington-based database available to defendants. And that is footnoted down below. In these footnotes, they talk about the videos where KJ talks about these things and say, for the past 19 months, up to the night this lawsuit was filed and even after, defendants continue to investigate and follow Tati, James, and Halo's activity. And defendants continue to publish defamatory material about plaintiffs, in many cases, republishing prior defamatory content on all of their social media platforms. Oh. Remember when that video got reposted and everybody was like, why is this video being reposted? The lawyers notice. And it seems from the declarations, James Westbrook also notices. Going on, the idea that defendant completely circumvented Washington sources in their research of Tati, her husband, and other family members and her business is wholly implausible, especially since defendant's own statements in May and June 2019 directly contradict the statement. So they're going after these statements in the declaration hard. Part because the declaration is what supports the motion and they're trying to kick the motion. But there's a dual purpose here because this is the lawyer chess game. It also calls into question directly if the defense is misleading the court and giving the court false information. So the first time all these parties show up into court, the thing that has been hammered in this motion is there were false statements made to the court. Having false statements proven false statements in an affidavit is not a good thing. And that's what plaintiffs are going to continue to hammer here. But the statements are made and they're contradicted on video. I don't know what you do with that. This is the next video, the June 2nd, 2019 video entitled "The Background Tati and James Don't Want You to Know." They indicated sick because I'm guessing that the title of the video doesn't have an apostrophe in it. Defendants indicated that they knew Tati and James's current address, but we're not going to reveal it in the video. This is also broken down in James's declaration. Then they show a copy of Halo's business information from the Nevada Secretary of State's records, which lists Tati and James's officers of the company and show their address in Washington. Even more revealing is the fact that defendants expressly redacted the street and city portion of Tati and James's Washington address before showing it to their viewers, meaning that defendant had a personal and physical interaction with said address and cannot claim to not have seen it. Didn't know that they lived in Washington, except that now there's this video. And the declaration says December. That kind of specific detail in signed affidavits matters. The particularity of law is not forgiving. And it's not, oh, well, maybe it was meant this way. It's in an affidavit. It matters. This talks about the law of the circulating of the materials or distributing the materials in Washington. Again, they talk about the declaration. Despite Paulson's assertions in her misleading declaration, defendants know that their defamatory materials have a circulation in Washington because the analytics for defendants' YouTube videos easily provides this information directly to defendants. And I said, oh, I forgot about that. Because I forgot about that. It's not something I do often on my channel, but you can go to your YouTube analytics and pull up where people are watching from and how much they're watching from. Don't judge my view counts. But you can see what state and how many views per state and the view duration and the watch time hour. And you can break this down by where the traffic's coming from, age, gender, all the things, which is helpful for advertising. But you can see where your top states are. But you can see it's literally one click in your analytics. And that's why they're saying there's no way you didn't know. And the fact that you chose not to click, if you like, oh, I don't want to look at my analytics, isn't going to fly with the court because you're obligated to be factual, not to ignore information that's at your fingertips. This gets into the brunt of harm test. The law, as stated, due to the nature of the defamation tort itself, a party is harmed wherever the defamatory material is published to a third person, regardless of the party's residency. We're gonna keep going. So this goes through the brunt of the harm test. The court should deny defendant's 12b6 motion, 12b6, because the complaint satisfies the Rule 8 requirements. And this gets on to the pleading requirements, and the 12b6 motion is just your blanket motion to dismiss for failure to state a claim. Courts, look, the rule, here's the rule. Courts must assume all well-pleaded, non-conclusory factual allegations contained in the complaint are true, and courts will determine whether such facts plausibly, like kind of maybe, give rise to an entitlement of relief. A claim for relief is plausible on its face when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. To cross the threshold from conceivable to plausible, the factual allegations must be sufficient to rise the entitlement to relief above a speculative level. This standard asks for more than the sheer possibility that a defendant has acted unlawfully, but is not akin to a probability requirement. So that's the standard. And it goes through each of the claims saying, is it reasonable that there can be relief here? And then the footnotes go through all of the stuff again, saying that Tati and James lived in Washington during this time. This gets into the specific causes of action that were asked to be dismissed. And we're not talking about defamation here because that wasn't raised. The ones that were raised were the intentional infliction of emotional distress, the negligent infliction of emotional distress, the Washington Consumer Protection Act, and the civil harassment. Those are the ones that are brought. Did I miss one? No, I didn't. Those are the ones that were brought. And so this goes allegation by allegation saying this is met and can't be dismissed because this is how it was pleaded. Defendant's arguments, however, fail to acknowledge that the IIED claim incorporates all of the preceding factual allegations in the complaint. We talked about this when I went over it, saying, okay, well, they were picking and choosing. And in a motion to dismiss, you can't pick and choose. You have to say, even given everything alleged, it's not enough. But in the defense motion, they were picking and choosing certain things, which is why I'm like, well, right? Because it annoyed me too. I was like, no, you have to take into account everything said and then say, even then, that's not enough. You can't just pick and choose. And then they get into the statements that are alleged that Tati has a history of defrauding lenders, engaging in fraud and money laundering, and cites it back to that declaration. Moreover, the 19-month campaign of harassment towards Tati and James and the onslaught of internet postings and videos, 40 plus videos alleged in the complaint, harassing and defaming Tati and James in that 19-month period with the intent of harming their business and causing them distress, also demonstrates the outrageous conduct of the defendants. And then it touches on what the defense alleged and then concludes with defendant's conduct is not a, quote, certain degree of rough language, unkindness, and lack of consideration, that it goes beyond that, sufficient for the IIED claim. It talks about the severe emotional distress. Defendants inexplicably rely on California law. And then it goes through the Washington standard for whether the emotional distress and severe emotional distress is sufficient. It talks about what was pled, that Tati had despair, nausea, loss of sleep, sense of helplessness, that those things are enough to be emotional distress. They go on to the negligent infliction of emotional distress, that defendants rely on California law and Ninth Circuit. And a Ninth Circuit dissenting opinion, but that does not show that defendants are entitled to a dismissal of the NIED claim. They get into the pleading standard under Rule 8 and say that defense argues that there needed to be a sworn declaration of these ailments or of the outcome of the distress. The plaintiffs are saying under Rule 8A, there is not a requirement to do that, and that contrary to defendants' conclusory arguments, plaintiffs have alleged that they incurred a medically diagnosable mental or emotional disorder, id, depression, and anxiety. And then it goes into more footnotes. We're at 120 footnotes, by the way, just so we're marking footnotes. Washington Consumer Protection Act. This is the one I was interested to see because I don't know as much about this particular act. And so seeing it in the motion to dismiss, I was like, okay, I would love to hear about that. Defendants' arguments fail to acknowledge the incorporation of the preceding factual allegations, which it did. Here's the thing. When you make a complaint, when you write the complaint, every allegation starts with incorporating everything above. So you don't restate it all. You state it, and then you incorporate it, and then you incorporate it, and you incorporate it so that everything pulls down without having to restate it every single time. And that's just common practice. Including the fact that defendants make their livelihood on YouTube and that the focus of their content is gossip or tea about other people. Can we just talk? Can we take a moment? Can we take a moment to appreciate the use of the word tea? The fact that like Tea Channel is now in legal complaints. Like there's a judge being like, oh, okay, what's tea? Like that's going to happen now. We have now gotten into tea in the legal documents, and I am happy for it. Like I was also happy to see PewDiePie mentioned in the other ones. It was irrelevant, but it still made me happy. I'm happy to see tea being mentioned. The number of defamatory videos defendant made about Tati is also relevant, as is the allegation that defendants have similarly targeted other people. Defendants' arguments misstate the public interest requirement. So it's saying, no, you got the law wrong. Here's what we are saying that it is. Plaintiffs do not have to prove that another person has been injured or threatened with injury. They only have to prove that defendant's unfair or deceptive pattern or practice could injure another person in the same way as plaintiffs. So again, the plaintiffs are saying, you've misstated it. This is what it is. The judge will get to decide. And then they get into the fact that defendant has monetized videos that consist of drama and tea and gossip. They have a pattern and practice of denigrating, harassing, and defaming others without bothering to verify their false statements. They're just going in. They're like, we're in. We have all the pages in the world now. We're going in. They get into the civil harassment claim. Defendants erroneously assert. We're going with erroneous throughout this thing. I'm here for it. Erroneously assert that testimony under oath regarding the harassment is a requirement at the initial pleading stage of the action. To the contrary, sworn testimony is not necessary until the court is deciding whether to grant a petition for an order of protection, like a restraining order. Here, the issue of the petition for order of protection has not yet been submitted to the court for a decision. Moreover, because of the First Amendment limitations of RCW 1014, the defamation and civil harassment claims are intertwined such that the civil harassment claim cannot be decided without first deciding the defendant's statements were defamatory, meaning you can't restrict somebody from speaking until you find that the speech is not protected speech. Defamatory speech is not protected. That's the argument. They use speciously. And I die. Second, defendants speciously argue. I put law and order approved because by this point we've moved on from erroneously and gotten to speciously, and I live. Argue that their harassing conduct of creating at least 40 videos and more than 100 internet posts with defamatory statements about plaintiff over the course of 19 months somehow is not directed at Tati and James, and then they go into the law with regard to that. And then say, specifically, the Western District of Washington previously held that defamatory statements posted on the internet meet the definitions of course of conduct and unlawful harassment. And I said, well, there's that. Because that's good to know. If this particular district had already said, no, it counts, there's nothing, you can't argue that it doesn't count because the court's like, no, this counts. Like this thing counts for that. And that's what it is. Defendant's interpretation of the statute would exclude a vast swath of harassing conduct and would be contrary to the Washington legislature's intended purpose. This gets into the third prong of the continuity of purpose, knowing and willful. And then we've got an example. For example, the complaint specifically alleges that Paulson has openly stated on her various platforms that she will not stop going after plaintiffs, and she has otherwise openly dared plaintiffs to sue defendants so that Paulson can misuse the discovery process to inflict more damage upon plaintiffs. Which is why my statement says words matter. Similarly, the complaint states defendants stated publicly that they intend to target plaintiff Tati, her family, and her business to do an expose on Tati as retribution for what defendants perceived as Tati's alleged mistreatment of another internet personality at 138. Here's why I call that out specifically. Because if the court is looking at this going, okay, well, here's what's being stated as the intent, and then the court rereads or relooks at that motion to dismiss, the motion to dismiss continues this same argument that's being alleged in the complaint, the same argument that no, essentially Tati wrecked herself or deserves it because of what she did to James. The whole complaint is like, but my sister's gross and she's targeting a young man with harmful stereotypes. So now the entire motion to dismiss is proving the plaintiff's point, and they've called it out. But the only way that can happen, this is not like specifically crafted by plaintiffs. This was alleged in the complaint. It feels like defendants couldn't help themselves, but also put it, the exact same conduct, into the motion to dismiss. And then it's called back here saying, we said in the complaint that this was the grounds and this was the purpose. And now this whole motion to dismiss continues on that same line of thinking and that same argument. It's just, oof. The court should deny the 12B7 motion because defendants failed to demonstrate joinder under Rule 19. Joinder. This is but Shane and Jeffree have to be in this case too. Defendants have failed to meet their burden of proving that social media personalities Shane Dawson and Jeffree Star should be joined. You can't have joinder in this case because Star and Dawson didn't make KJ say what she said. It's about what KJ said. Then we've got the request to strike evidence submitted by defendants. So this is saying to the court, hey, the shit they submitted, we don't think you can rely on it as evidence, which, given the extra page limits, they have time to do. And then they get into local rule CR7G and the federal rules of evidence. Plaintiffs object and move to strike the declaration submitted by Michael P. Brown, the lawyer, in its entirety as it lacks personal knowledge, foundation, and includes hearsay. And then it gets into the lawyer's declaration and goes in. Mr. Brown's statement referencing Zillow.com in the second paragraph of his declaration is inadmissible because it lacks foundation. Right? It's Zillow. Like, Zillow's not evidence. Zillow's like third level of like, maybe it got pulled from another thing. You don't even know where Zillow is pulling from specifically. And so much hearsay. And then they talk about the fact that it's inadmissible because it lacks foundation and personal knowledge. Defendants use Mr. Brown's statement that Zillow.com listing prove that the Westbrooks did not list their Los Angeles home for sale until September 2020. However, the screenshot fails to actually identify the Westbrooks anywhere in the image. Like, okay, and how do we know that's their address? Because nothing verifies that that's them. In addition, the entire statement is hearsay, as a screenshot does not actually show a purchase or sale of the property, but instead shows that Zillow, a third-party website, shares information that has been obtained from a real estate broker. Third, Brown failed to prove any evidence that the Westbrooks lived in the house after they purchased it, which they never did. Oof. Second, the remainder of Brown's statements, which are about Glam Life Guru's social media accounts, are inadmissible because Mr. Brown lacks the foundation and personal knowledge to attest to who used the Twitter and Instagram accounts on those days, which is a fair point. And then it gets in again to Miss Westbrook is a public figure. She's known, and that's why she might not be posting at contemporaneously with where she is. And then says defendants spent over a page in their motion offering pure speculation and various conjecture about where Miss Westbrook was living based on the date and location of each post. Conclusion, plaintiffs respectfully request that the court deny defendant's motion to dismiss. This is the plaintiff's opposition for defendant's request for judicial notice, saying, hey, judge, you can't take notice of this shit. Defendants have filed a separate request for judicial notice in addition to their motion to dismiss plaintiff's complaint in an attempt to rewrite the facts in this case and insert characters who have nothing to do with the allegations regarding defendants defaming plaintiffs Tati, James, and Halo through over 80 videos and 100 social media posts. We've got it. 80 videos, over 100 social media postings. We know. Defendant relies on citations to the appendix, which contains defendant's request for judicial notice. It talks about the sections of that, none of which have anything to do with the cause of action in plaintiff's complaint, because it's all the links to all those videos that we pulled up live. And then it talks about the standard, the legal standard. It has to be for judicial notice, generally known within the trial court's territorial jurisdiction, or can be accurately and readily determined from the source whose accuracy cannot be reasonably questioned. As if you had a case where it's like, can the court take judicial notice of the fact that August, whatever day, whatever year, was a Thursday? And the court can say, yes, we can take judicial notice of the fact that this particular date on the calendar was a Thursday, because it's an uncontroverted and known fact. It doesn't necessarily need to be admitted into evidence. And then it can have judicial notice taken of it because it's uncontroverted. That's getting into what judicial notice is generally used for. The fact of a thing. Can the court take judicial notice of the fact that there is a photo that exists on the internet that shows this thing? Sure, but you can't say that the underlying thing is true. The existence of the thing is different. The documents requested are not proper for judicial notice as a matter of law because they're unauthenticated YouTube videos. True. And no foundation has been laid for requesting judicial notice of the content of the articles and videos. And they don't rely on the fact that they exist. They rely on the content. Defendants state that they are not asking this court to take judicial notice of the truth of anything contained in the complaint, but then they do. This is the Swanson complaint. They say Swanson said in a sworn declaration that they lived in LA, and then they ask the court to take judicial notice of that fact. Defendants rely on statements purportedly contained in the Swanson complaint, but in actuality are nowhere to be found therein. We have to get to footnote 8. Hold on. We didn't get to footnote 8 yet. The Westbrooks reside in Los Angeles County and were citizens of California from 2016 through the filing of this complaint in October 2020. This is the statement that Swanson made that the defendants rely on in their motion. And then this footnote says, though this statement was made under penalty of perjury in the Swanson complaint, it is knowingly, patently false, and it has been proffered in bad faith, those are big allegations, by defendants and defense counsel, calling out Brown particularly. To be certain, defendants knew that the information in the Swanson complaint was false at the time it was filed. Just a month prior to the filing of said complaint, Swanson's, defendant published a video covering the sale of the Westbrooks' Los Angeles property, wherein Miss Paulson states that the Westbrooks have moved to Seattle a long while prior to said sale. Prior to said video, Miss Paulson published another video in June 2019, wherein she showed her viewers documents establishing that Miss Paulson knew the Westbrooks lived in Washington as far back as June 2019. And this is attached in the declaration. As such, Miss Paulson was well aware that the allegations in the Swanson complaint were false at the time of the Swanson complaint was filed. Yeah. They just went in and laid it out saying, you've relied on this and you've led the court or asked the court to rely on it, and it's knowingly false. That's why the bad faith is in there. Bad faith are big words. It doesn't sound like it's big words, but those are big words to a court. Then we're getting into the statements relied on that are in the Swanson complaint, but they're actually not in the Swanson complaint. This is the $5 million, y'all. We talked about it. For instance, defendants state just days after defendants broke the story, yes, we know, of Swanson's $5 million suit against the Westbrooks, seeking to deflect attention from those allegations and that $5 million claim. However, and then that goes on to say, hey, the Westbrooks filed this lawsuit to deflect from that lawsuit. However, nowhere in the Swanson complaint does it say that it is a $5 million claim. I have been saying this everybody's like, it's a $5 million complaint. It's not. I know it. Y'all know it because you're law nerds. And when I saw it in that motion to dismiss, I was like, but it's not a $5 million complaint. Anyway, it's in here too. Plaintiffs do not dispute the existence of the Swanson complaint. Plaintiffs do dispute the veracity of the truth of the statements contained wherein. Defendants' new statements regarding the Westbrooks' residency contained in the Swanson complaint were false, yet relied upon such statements in bad faith. Oh, it's not just in a footnote, friends. We're pulling this up to the main stage. And I feel like they're digging at Swanson a little bit in this too. The Swanson complaint states under penalty of perjury that Mr. and Mrs. Westbrook are residents of California. Defendants then rely upon that statement as a basis for jurisdictional arguments in their motion. The statement is knowingly false. Counsel knew it to be false, Mr. Brown, at the time it was made, and thus proffered such argument in bad faith and in breach of his duty of candor as an officer of the court. Counsel then attempted to support the statement with his own findings from Miss Westbrook's social media in order to somehow evidence that Miss Westbrook lives in California. She does not, but failed to disclose that Miss Westbrook's social media account has published pictures of Miss Westbrook in the exact same Seattle location as early as February 2019 that he contends do not exist prior to December 2019. The failure to disclose such earlier postings in light of the arguments being made by defendants indicates that Mr. Brown's presentation and use of the evidence in his declaration is being proffered for the purpose of misleading the court about a fact defendants knew to be false. Yikes. Because this testimony is inexplicably included in Mr. Brown's declaration and not Ms. Paulson's, the testimony of Mr. Brown carries with it the heightened duty of candor with the court as an officer of the court. Don't rile the lawyers. And other lawyers have riled the lawyers. And the lawyers went in. The lawyers just went in on this saying, no, it's misleading, and you're relying on it knowing that it's false. And this gets into the Federal Rule of Civil Procedure 11B. This is a sassy footnote. By presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advancing it, an attorney certifies to the best of the person's knowledge, information, and belief formed after an inquiry reasonable under the circumstances that the factual connections have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity to further investigation or discovery. And the denials of factual contentions are warranted on the evidence or if specifically so identified, are reasonably based on belief or lack of information. These videos are expressly identified as being crucial evidence of defamation and harassment in the complaint. Plaintiffs are saying the defense attorney would have known because he's representing against this case and he would have watched all of those videos. And those videos contain the things that we've talked about. That's how we know and are making this argument that we're making. As such, defendants and their counsel are intentionally attempting to mislead this court by now relying on such false statements as to Mr. and Mrs. Westbrook's state of domicile at the time defendants targeted plaintiffs with their conduct alleged in the operative complaint. Oof. Appendix B is misleading as it ostensibly requests judicial notice of videos, yet actually requests judicial notice of web pages as well. And it goes into all the links that are listed and that they are some videos, some websites, some news articles. These are all the things in that attachment that we talked about. Further, courts generally deny requests to take judicial notice of extrinsic documents. It talks about what the court may take judicial notice of, which I have broken down. It can the existence of the thing, but not the fact of the thing. Defendants improperly cite to unspecified links to videos in Appendix B, which are not the proper subject of judicial notice. Then we get into my favorite part. Defendants not only improperly request judicial notice of videos without proper authentication, but rely on the contents of those videos, many of which have been made by unreliable and disinterested third parties. Disinterested meaning they're not parties to the suit here. Then they just go in and go off. The content appears, talking about those list of videos, the content appears to largely contain the uninformed and irrelevant personal opinions of individuals of which there is no evidence submitted to qualify their opinions as having any credibility, be given any weight, or to otherwise provide any sense of reliability in the method in which the opinions were formulated. Rather, the videos appear to contain nothing more than a motley group of gossips attempting to build a monument to the gods of speculation. I'm dead. That is summarizing all of those videos listed. By the way, we love the gods of speculation. It is the contents of those videos which defendants are now attempting to ask this court to accept as indisputable fact. This, the court is forbidden to do. Somewhere, whoever works for this judge is just going, this is magic. And I love this. I love this paragraph so much. Now that how many pages in are we in the hundreds of pages of this? Oh, we're on page 37 of 125. We're going to have to move faster. It's just so great. And then it concludes, defendant's fact section is entirely reliant upon the court reviewing hours of footage of people of unknown credibility, motive, education, and bias about matters upon which they have no verifiable expertise or personal knowledge in order to provide ill-conceived opinions. CEG Appendix B12 link to Trisha Paytas's YouTube video, and there's a footnote. Trisha Paytas has her own footnote. Trisha Paytas is apparently an internet adult entertainer whose purported statements in a video have no bearing on whether the Westbrooks and Halo Beauty were defamed by defendants. Defendants and its counsel's attempt to include such video in the record of this case has been done in bad faith. The facts section of defendant's motion is not based on facts, only opinions of third parties with no interest in the claim, because the entire facts section is based on those videos. Conclusion, plaintiffs request this court deny defendant's request for judicial notice and that it strike any and all portion of defendant's motion to dismiss that are reliant upon items identified in defendant's appendix A and B. So strike it is what they're saying. Now, this is the order. And then if and when a judge grants it, this will be lined out and the judge can sign it. But this is their proposed order saying just deny it. Then we get into the declarations. Tati, in her declaration, states that she's a resident of Washington. She was born in Washington. Parts of her business and what her business is, that she doesn't manage her own social account on her own. So somebody will help her with that. That she's recognizable. That for her safety, she does not want the general public to know where she is at all times. And it talks about that she travels, probably not this year, none of us do, post pictures from worldwide locations. And it goes into what she does on social media, born and raised in Washington, that she and her husband had at one time lived in California and do not anymore, that they have signed a lease in December 2018 is when they took possession of their new place. That's attached to James's declaration, that their taxes are filed in Washington, There is a screenshot from her Instagram account from February 18th, 2019. The picture in the Instagram post below was taken of me in my Washington residence. As is demonstrated in the picture below, this is one of many social media posts of pictures that I obviously did not take myself because how could you? This we've all seen down here at the bottom, February 18th, 2019. Defendants have in this case published approximately 80 plus videos concerning me, and it goes into the different videos and the timestamps about what was said, about the websites that were researched. This is in James's declaration as well, that James downloaded these. They have provided Dropbox links. These will all be, I didn't mean to link it. These will all be in the description box if you guys want to watch them yourselves. So you can go to Dropbox and pull up these videos. Some of them are down, some of them are up. But either way, you can go through the link in the Dropbox and watch them. This is the past Tati and James didn't want you to know. Tati talks about watching this video, what she saw at 3 minutes, 13 minutes, 55 minutes, the 3 weeks of nonstop research, the expose. Her husband downloaded it. There's a link. That's her declaration. I watched it. It said this. I know this person to be Kati Joy Paulson. This is what she has said about me. This is what I saw. And then a note that this video is not currently available on YouTube. So they're in the Dropbox. James's declaration. James says a lot of the same stuff as Tati about living in Washington, the business being in Washington, working in Halo, what he does with Halo, what the channel is, and then how YouTube channels make money, how they derive income, showing and really going to the fact that there is income to be made in different ways on YouTube. And this goes to the fact that when KJ said in her declaration, I don't derive income, it's saying, no, this is how income can be made. And I don't know if I have subscribers in Washington. James is saying, in my experience, this is how you would know. And this goes into it. He talks about merchandise and without a crystal ball merchandise and the just facts. It's just facts. I wonder if this is a subtle indication that the things she says on her channel are to be taken as true, because that would go to the defamation. Like, are you advertising that what you say is to be taken as true, that it's not commentary, that it's you stating facts? They talk about AdSense revenue, how AdSense is derived, and then goes into the fact that a YouTube channel owner can drill down into analytics and break down viewers by geographic location, which I showed you. So again, going to the fact that they believe the statements in the declaration are not true. There are links to the videos where it's a hello to Patricia from Washington and breaking down what James has seen, and that the things that were seen and the things that were heard are the basis for this motion. So this is why there's an affidavit that links back to the evidence saying, I saw someone I know to be this person say this thing. This goes to the declaration showing in this screenshot of the video, and the video is included, that down here it says, hi, I'm from Washington. There's others. Hello from Seattle. And these are all referenced in the motion. A different hi from Seattle. Then it gets into the Twitter stuff, and apparently there were donations being asked for and super chats, and talking about how super chats work and where they come from. And then I said, I remember this clip. This was November 25th, 2020, update on lawsuit responding to criticism, how to give back, which James says he downloaded before it was deleted or privated. And this was not everything we say as content creators is true. I remember getting that clip and DMs from a lot of you, and I'm like, this is linking other videos from up to December 18th. Things have gone too far. This was downloaded before it was either deleted or privated. And it states there is a lot of stuff that's been put out there by me that's just flat out lies, and it's for views. There's a clip of this on Twitter. I didn't know this was going to be referenced in this when we talked about this literally yesterday on Twitter, because I was going through Twitter to look for something else, and we saw the clip on Saltsy's Twitter, and I was like, oh, is this out of context? Most of you said in statements that you thought it was a misspeak, but it's in here now. And when I said this is going to come up at deposition, here's your proof. Here's your proof that it's going to come up at deposition, because it's in this declaration. That's how you know that this is going to come up at deposition. This was said days ago from when this was filed. Below is a list of videos from defendants' various social media platforms, and it goes into videos that reference this in their statement. And it is, we're just going to scroll. It's a long list, but there's also a little shade. Some of these postings have been deleted, so I'm unable to testify as to the exact number with precision. Just another note that shit's been deleted from their perspective. And this is all of the videos. I love that they point out specific parts of the videos, and there are Dropbox links in the footnotes. At approximately 17 minutes into this video, Ms. Paulson stated that my wife is just a failed actress from Washington. If you've seen that clip on social, I just want to know in the comments. Just leave it down. Let me know if you've seen that clip. A true and correct copy of said video without live chat or comments that I had downloaded from Defendants Without a Crystal Ball YouTube channel is in a Dropbox for the court's convenience. And there it is. More videos. Then it goes into what videos have been privated or deleted. More videos. More videos are now at AAA. It appears this video is no longer available. More videos. And then talks about which ones have been deleted. This video appears to be deleted. However, I've reviewed the video, which was uploaded to YouTube 2 days before filing this lawsuit. At approximately 28 minutes into the video, Ms. Paulson stated that my wife and I were never going to sue her. And if we were going to sue her, we would have done so already. A true and correct copy of that video without live chat or comments is downloaded in a Dropbox for the court's convenience. So if you have never seen that video and you want to, there it is. We're now in triple Q. This video appears to have been deleted. This video was also uploaded to YouTube 2 days before filing this lawsuit. At approximately 65 minutes into this video, Ms. Paulson stated that my wife and I are never going to sue her, as we already sent her 4 cease and desist letters, and she was reporting on public documents. She further indicated in that video that my wife and I love to intimidate with nothing to back it. Quote, a true and correct copy of this video is here. And then it lists which ones have been or are suspected to have been deleted, which ones are members only, and which have been privated. We're now in triples. Again, it lists which have been privated and deleted, which are available. And then it gets into this Sephora arrived at my house again with the researching everywhere and getting into the documents in Washington. And we're still not done. And I've been talking for a very long time. This video is going to be as long as a live stream. It gets into the Swanson complaint and then says, and look, this has the dual purpose of also kind of clapping back at Clark too. The reason it's relevant to this is because KJ relied on Swanson's statement in her motion, but then they get to respond and say, Clark Swanson knew my wife and I lived in Washington well before the Swanson complaint was filed in October 2020. So now they are clapping also at Clark's sworn complaint in the business partner lawsuit, saying, as an officer of Halo Beauty Partners, Mr. Swanson filed corporate documents listing the Washington residence address of me and my wife on the documents. So Swanson knew it was false. They're saying when he put it into the complaint, and they're saying this is why he knew. Another video, Dropbox link. Then we've got the screenshot. This is referred to within the motion, of course, the screenshot, and then there's a screenshot of it. If you have seen this video, you know. This is the addresses of where they live from that Nevada filing. And the link is in there. At 55 minutes is where she's saying, I blacked it out. But it's also showing that she engaged with it and saw that it was there because she chose to black it out. This gets into the Paulson Declaration. I have reviewed, this is from James, I have reviewed Ms. Paulson's declaration submitted in conjunction with the defendant's motion to dismiss. Upon review, based on my general knowledge regarding the business of social media and my specific review of Ms. Paulson's videos, Ms. Paulson's declaration appears to contain several untrue statements. I told you they were going to go hard on this. One of the statements I believe to be untrue is the defendant has no employees. I personally recall viewing a video wherein Ms. Paulson stated that her husband was an employee of defendants, and another view wherein her moderator, Jesse Bear, said, best employer ever. A screenshot I have obtained from the video is below. I've seen this on social. They're going in on the potential and seeming false statements in that declaration. I've personally witnessed defendants ask their Twitter followers, subscribers, and viewers, some of whom they knew were located in Washington, to donate money for the cost of research and obtaining records to expose me and my wife. If any of you appreciate my investigative work on the Tati and James Westbrook, please consider a tip to my Ko-fi. I don't know what a Ko-fi account is. I spent hundreds researching and paying for court records. This I've also seen on Salty's Twitter. P.S. I was biased about Tati because I've done months of research on this story and her husband is a damn fraud. You shouldn't want frauds in the community, my opinion, from October 30th, 2020. Isn't that the day the lawsuit was filed? Wasn't it filed October 30th? Isn't that when she got notice? You can't make this shit up, you guys. We've got more declarations. This is the lease agreement. We're going to pass it. And now we get to the next declaration from Macy Strome. I'm going to go with Strome. I pronounce things badly. This is the beginning of the declaration, resident of Washington, and we're going to get into why it's relevant. I was a supporter of Tati Westbrook 2018 to 2019. Both my daughter and myself would frequently rewatch her channel. They supported her because she was from Washington and they're from Washington. I'm aware that Tati has ownership connection with Halo. I had contemplated purchasing Halo's vitamins in June 2019. I decided to research Halo's vitamins and did a YouTube search to see reviews on them. A video from a person known as Katie Joy Paulson from a YouTube channel called Without a Crystal Ball was the first video to show up in my search results. As such, I watched Ms. Paulson's video. I then subsequently watched several other videos from Ms. Paulson on Tati, her husband, and Halo. In watching and following Ms. Paulson's coverage of Tati, James, and Halo in June 2019 and thereafter, I heard Ms. Paulson make statements, and I perceived she was stating as fact, such as James Westbrook has a long criminal rap sheet and was a career criminal. James Westbrook stole all the equity out of his mother's home by taking out reverse mortgages and then caused his mother's untimely death by depriving her of oxygen for inheritance purposes. Tati's vitamins sold through Halo are without a doubt a fake snake oil, and that taking the vitamins would be harmful to one's health, that the Westbrooks scrubbed the internet to remove harmful information about themselves. Tati made James Charles reach out to Ms. Paulson to take down harmful videos from her YouTube channel about the Westbrooks. Based upon these representations about James Westbrook's Tati and Halo, I formulated a negative opinion of them and believed them to be dishonest people running a dishonest company that I did not want to support. Thus, based exclusively on these statements, I decided not to purchase Halo. And that's where Tati's going to prove damages in this case. This is one statement. They only have to prove one. I think there will probably be others, but they only have to prove one. And this is one person saying, I believed what KJ was saying was true. I believed these things about the vitamins and about Tati and James. And because of that, I stopped supporting their channel, stopped watching, and didn't buy Halo. And I've seen comments like that in the comment section on my videos. So I know this isn't the only person. This is just someone who lives in Washington saying, look, the harm is here. So it goes to jurisdiction too. Dual purpose. And then it talks about Bye Sister saying through all of those controversies, this person saying it didn't rise to them changing their opinion because that was kind of drama. It was Ms. Paulson's statements. There's another one. Declaration of Hope Walker. Lives in Washington, over 18, supported Tati 2017 to 2019. I'm also aware of the Halo product sells in the state of Washington, hair, skin, nails vitamins because I was a fan of Tati. I purchased vitamins from Halo to try and had them sent to my Washington residence. This is someone who directly purchased Halo in Washington, personally found Halo's vitamins to be effective. They worked well for me. And in May 2019, I was preparing to purchase a subscription to Halo's vitamins at $40 a month. In or about the end of May 2019, I started to watch videos on YouTube on a channel called Without a Crystal Ball, which features KJ. In addition, started following KJ on social. I personally saw KJ's social media postings and videos regularly attacking Miss Westbrook, her husband James, and their company Halo. Two videos in particular stood out. Sephora arrived at my house. The past James and Tati don't want you to know. Those are all going to be linked. Specifically, prior to viewing the content, I thought Tati and James were good people trying to do good things in the world, and they had created a great product through Halo that I was able to afford and was happy to support in the state of Washington. We know you're in Washington. It's a jurisdiction motion. We get it. However, my perception changed drastically when I saw that Ms. Paulson claimed in above-mentioned videos and on her Twitter account that she had done extensive research on James and thereafter portrayed him as having personally taken out reverse mortgages on his mother's house to steal all of her equity in her own property, and as having removed his mother's oxygen in order to cause her untimely death so that he could steal her assets. Based on Ms. Paulson's statements and social media posts on these topics, I believe Ms. Paulson's statements and representations as to her portrayal of James Westbrook, and by extension through marriage Tati, to be true. It was Ms. Paulson's specific claim to have carefully researched and explored public records and thereafter to have found James to be a career criminal as part of her story research that was the final determination for me to change my feelings against the Westbrooks. Then she talks about why these particular statements affected her and caused her to develop negative feelings towards James, Tati, and Halo, and to stop purchasing Halo because she had taken care of her own mother for many years before she passed away, and I knew how difficult it is to make end-of-life and estate-related decisions. However, the way Ms. Paulson described the behavior of Mr. Westbrook, and by extension Tati, was so appalling that I was completely turned off to Halo and did not want to support a business owned by a married couple that I was led to believe stole from a parent and caused the untimely death of a parent for inheritance purposes. That's damages. As a direct result of Ms. Paulson's representations on this topic alone, I decided to go elsewhere for my vitamins, unsubscribe from Tati's YouTube channel, and stopped watching her videos. This again touches on Dramageddon, Karmageddon, and said that those things did not sway this person. And then she says it very clearly. Rather, it was the specific allegations and representations that Ms. Paulson made portraying Ms. Westbrook, particularly as a career criminal and also as a person that obtained so many reverse mortgages on his mother's property, that he stole all of the equity from her home, that he caused her untimely death by personally removing his mother's oxygen so that he could steal her assets, that exclusively impacted my decision to stop buying products from Halo and to stop watching Tati's monetized content on her channel. That's what it is. Those are two declarations since this case was filed in October. By the time this goes to trial, how many people are going to share this same story? Because again, from what I've seen, there are others. And that's something that should have been taken into consideration by the defense in the, first cease and desist, or the second, or the third, or the fourth, in my opinion. Declaration of Kim Fulmer. This one's interesting to me. I was a moderator for the live stream of one of Katie Paulson's YouTube channels, Without a Crystal Ball, from July 2019 through August 2019. So for about a month. But this is a former moderator. I became a moderator after being a subscriber for about a month, reached out for help with moderating. She asked for volunteers. Part of my duties as a moderator was to delete negative comments. Around August, I had a falling out. She blocked me as a moderator. After I stopped moderating, another subscriber and supporter of Ms. Paulson's YouTube channel and Twitter page, who I knew to believe Lori Ann Barnhart, Twitter usernames Lori Ann at Bloodtall and this lab one 05059, threatened multiple individuals, including myself, with violence on Twitter, specifically because of my falling out with Ms. Paulson. Lori Ann made threats against me and threatened to have me murdered by a biker gang. Now, we've gotten into maybe this is the murderous conspiracy that's mentioned in the other thing. Maybe we have murder again. We are in a civil defamation suit. We have talked for 100 years today, and we have come back around to murder. These are serious allegations. Below are actual screenshots from May 2020 that I obtained from my Twitter account that contained Ms. Barnhart's public threats of violence against myself and others. Okay. Oh, Unirock. See, Unirock too. I have Facebook friends that are also my Twitter friends who can verify who I am and who my family is. So if Steve McRae, he keeps getting roped into this stuff, thinks he can continue harassing me, my family will protect me, and they are all over the US, and then posts the Guardian Angels and another biker group, purportedly. I myself, along with several others, have been targeted by these people for defending Katie. I've made it clear that if they continue to harass me, they will have consequences one way or another, and then just dimes out the accounts, it looks like. Michelle is Kim from Unveiling the Mask. I will give anyone my address. Come for me. I have relatives that have spent time in prison who protect their own and are not afraid to go back to prison. I know who the people are behind this hate campaign. After receiving threats of violence, I personally conducted an investigation to determine that Miss Barnhart is a resident of the state of Washington. Now, we know this is one of KJ's ride or dies. Isn't she the one on Twitter? You guys, let me know in the comments. Isn't she the one on Twitter that went after Salty initially and said, you're not even a real lawyer. You're pretending to be a lawyer. Pretending to be a lawyer is a crime. And Salty was like, I'm in my office all day. Come on by. I will show you who I am. I am a real lawyer, and we can go over the complaint if you want to. That happened like right as this was filed in October. I think this is the same person. I want to know in the comments or tag me on Twitter. But she's a resident of Washington. So if she's one of the ride or dies, then KJ knows she has people in Washington. Oof. And she works for Washington. She works for the Office of the Secretary of Transportation for the state of Washington. She lives and works in Washington. This all goes again to that declaration and having sufficient contacts. I think what we just saw happen here is that one of KJ's ride or dies tried to mess with Salty on Twitter and riled the lawyer. And the lawyer was like, okay, but you also live in Washington. And because you also live in Washington, it's relevant to this motion. And it's relevant to this motion because KJ said in her sworn declaration that she doesn't have contacts and subscribers and doesn't know that anybody's in Washington. But here we are. I have observed tweets from Without a Crystal Ball official, which I'm informed is Miss Paulson herself, that she operates in certain tweets. Miss Paulson has interacted with Miss Lori Ann Barnhart and vice versa. Paulson refers to the account that belongs to Blood Tall as her fiercest and loyalist supporters. And there's a screenshot. Such a strong person. I want to be like you when I grow up, even though I'm older than you. KJ said my fiercest and loyalist next to Blood Tall and a Real Housewife Zero. Below are screenshots of additional tweets obtained from my Twitter. These are from November 6, 2020. So these are contemporaneous. This is Lori Ann is a real person and you've targeted her, causing her extreme and unwanted harassment. My attorney sent you a letter. Is this the response? I think this is the response regarding the Salty stuff. Lori Ann is a real person and you've targeted her, causing her extreme and unwanted harassment. My attorney sent you a letter yesterday explaining each ethics violations. Oh, riling the lawyers. This is part of why the ethics violations for KJ's lawyer are so prominently featured in this motion, I would expect. My attorney sent you a letter yesterday explaining each ethics violations you are violating with this Twitter spectacle and further requesting you cease contact with me. Stop. I think that was all in that same thread of activity. I've also obtained screenshots of other tweets from Lori Ann's Twitter, wherein Miss Barnhart publicly displays her support for Miss Paulson from June 2020. So this is all going back to that support and having supporters in Washington. I have also observed on a video published on December 8th, 2020 on Miss Paulson's YouTube channel. This is the video. Here's the link. She shared her computer screen and here's the timestamps. And then in her share, her messages were open and it shows who she's DMing with. And I see, let's see who we see. I see Nate. I don't know who this is. I see Kate Tenbaraj. I don't know if I'm pronouncing that properly, but she's the one that's been writing about Jeffree Star. And it looks like there's a comment here. My attorney said we have no. So again, KJ's making statements about what her attorney told her. And then Lori Ann is right down here too. So these are conversations happening in December. Here's the interesting thing, because here's how this plays out in part. We now know these conversations are happening. It's in this motion, but those are all subject to discovery. So I imagine that Salty and his team are like, if we don't see these in discovery, it's going to be a big problem. We need to see these. We need to see them. We need to see them in discovery. And then it goes on saying, in addition, Ms. Barnhart making threats involving violence, I was disturbed to discover in my investigation against Ms. Barnhart that she had criminal charges involving acts of violence filed against her in the state of Washington. That's okay. Based on this discovery and the prior threats that she had made against me personally and others generally, I have been and continue to be in reasonable fear It is my personal observation that Ms. Paulson intentionally instructs, encourages, and or condones Ms. Barnhart's harassment and intimidation of Ms. Paulson's perceived enemies. Attached Exhibit 1 is a true and correct copy of the redacted charging documents against Lorianne from 2012, obtained from the Superior Court of Washington, Snohomish County. So also a criminal complaint is what they're finding. And this is all relevant because she's in Washington and it goes to this motion. But I also think it goes to don't rile the lawyers. And it also goes to the fact that people can become involved in this case through their actions. And it will be very, very interesting to see. Ooh, it's gotten very dark. I apologize. I don't know why I'm all red, but it's gotten very dark and the lighting has changed. Fantastic. We're just gonna keep rolling because I've talked forever. And even though the light has now changed, it is time to wrap this up and get it uploaded for you. Thank you for being here with me. Do the YouTube-y things. You know what they are. And I will see you in the next one. Don't forget to like and subscribe. Connect with me everywhere. I'm at the Emily D. Baker. The podcast is the Get Legit Law and Shit podcast. So if you're ready to ride it on, head over to lawnerdshop.com, your place for all your law nerd needs, stickers, t-shirts, sweatshirts, and more coming soon. If you guys want to join the text, just text emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube